Hello, and welcome back to the Listen and Learn series from the Law School Toolbox. In the first part of this two-part series, we will be reviewing the law for incidental, reliance, and restitution damages. After this episode, check out part 2, where we will be applying the law to facts in exam hypos. Today, we are going to be expanding on the topic of legal remedies for breach of contract, which we started covering in a previous episode. Legal remedies are also known as money damages and are distinguished from equitable remedies like specific performance, rescission, and reformation. When we talk about legal remedies, we're typically talking about 5 types of damages. 1. Expectation damages. 2. Consequential damages. 3. Incidental damages. 4. Reliance damages. And 5. Restitution damages. In our previous episode, which we'll link to in the show notes, we talked about expectation damages and consequential damages. Today, we're going to finish our discussion by focusing on the remaining 3 types of damages: incidental, reliance, and restitution. Note that this episode will assume that you are already familiar with the rules governing expectation and consequential damages, so you should check out our previous episode if you need a refresher. All right, as usual, let's start by going over the rules governing each type of damages, starting with incidental damages. Incidental damages are the reasonable costs incurred as a result of a breach of contract. A party can recover incidental damages in addition to expectation and consequential damages. To illustrate this rule, let's say that I run a widget store on your street, and I breach an agreement to sell you 100 widgets at $10 per widget. As a result of my breach, you buy replacement widgets from another seller across town at the lowest cost you can find, which is $11 a widget. In addition to paying the increased cost of the widgets, you also need to rent a car to pick up the widgets from the new seller across town at a cost of $50. As we discussed last time, the $100 increased cost of the widgets are expectation damages because they result directly from the breach. The $50 you spent on the car, however, are incidental damages. They are damages you reasonably incurred after the breach in trying to deal with the consequences of the breach. Because you can recover both expectation and incidental damages, you can recover a total of $150. Let's move on to the rule for reliance damages. Reliance damages are generally the expenditures made by a party in reliance on a contract and are an attempt to put the non-breaching party in the position it would have been in if the contract never existed. Reliance damages are available when 1. A plaintiff acted in reliance on the defendant's agreement to perform under a contract, and 2. The plaintiff's reliance was foreseeable. Reliance damages are typically awarded if expectation damages are too speculative or if the plaintiff suffered no expectation loss. A party cannot recover both expectation and reliance damages. To illustrate this rule, let's say you agreed to sell me a car for $5,000. In anticipation of your performance, I purchased several accessories for that specific car at a cost of $300. You breached the agreement, and I end up buying a different car for $5,500. The $500 extra I paid for the substitute car are my expectation damages, because they result directly from the breach. The $300 I paid for the accessories are my reliance damages. They don't flow from your breach, but rather from your promise to perform. In other words, unlike incidental damages, I would have incurred these costs even if you performed as promised. But because you breached, these costs are now wasted. Note that I can't recover both the $500 expectation damages and the $300 reliance damages. In this example, I would almost certainly seek the greater expectation damages. But what if we change the facts so that the substitute car only cost $5,000, the same amount as the car you promised me? Under those facts, I would have suffered no expectation loss. I expected to pay $5,000 for your car, and instead I paid $5,000 for a car from a different seller. But I would still have wasted $300 on those accessories for your car. In that situation, I would seek to recover those $300 as reliance damages. Okay, let's finish up our rules with restitution. Restitution is awarded to prevent unjust enrichment and is available when one party confers a benefit onto another party even if there is no enforceable contract. Damages will be awarded based either on the market value of the plaintiff's performance or on the value of the benefit conferred upon the defendant. As with reliance damages, restitution is typically awarded if expectation damages are too speculative or if the plaintiff suffered no expectation loss. A party cannot recover both expectation and restitution damages. Moreover, restitution is not limited to the non-breaching party. Under the Restatement Second of Contracts, a party is entitled to restitution for any benefit that they have conferred by way of part performance in excess of the loss that they have caused by their own breach. The easiest illustration of this rule involves the payment of money. If I paid you for a good or a service that I did not receive, then I conferred an obvious benefit on you. When the benefit is strictly monetary, there is no difference between the market value of the performance and the value conferred on the plaintiff. In an action for restitution, you would simply return the money I already paid you. Things become slightly more complicated with other kinds of performance. For example, let's say you agree to pay me $5,000 to do some landscaping work on your property. The work is supposed to take me 3 weeks. After I complete the first week of work, you change your mind and repudiate the contract. Clearly, you would be unjustly enriched if you were allowed to retain the benefits of my work without paying me. In an action for restitution, you would be required to pay me either the market value of my labor or the value of the benefit you received, which would likely be measured by any increase in the value of your property. Now, in this situation, I would probably just sue for expectation damages. After all, we agreed you would pay me $5,000, so the expectation damages are not speculative. And I have clearly suffered expectation loss by your refusal to pay. So there's really no reason for me here to seek restitution in this case. But as we'll see in our first hypo, there are circumstances where restitution might be appropriate, even where expectation damages are available. Thanks for watching, and be sure to stay tuned for part 2, where we apply this law to facts. Please subscribe, hit a like button, and leave us a comment. And check back for future episodes in the Listen and Learn series.